Unfortunate because not only do 1 in 4 women in America experience violence at the hands of an intimate partner, but also because the grim conclusion of this particular relationship. The losses brought in this circumstance are felt not only by Anitra's family and friends, the Fort Valley State University community, this community, as well as the defendant's family. To highlight the gravity of domestic violence in all of our communities, this morning we are wearing purple, Anitra's favorite color, and also the color used for domestic violence awareness. Many members of my staff came together to bring this case to the courtroom for trial, both behind the scenes and in the limelight. The efforts of all are recognized and much appreciated. This morning, I have with me the 2 senior assistant district attorneys in my office that brought the case to trial, Neil Haverson, who is a 17-year veteran prosecutor, and Don Baskin, who is a 20-year veteran prosecutor. And they presented this case to the jury, and they are here now to answer some questions about the trial. By necessity, those questions will be limited so as not to prejudice any potential appellate aspects of this case and jeopardize the justice that was attained last week. Thank you. So the first question that we will start with is, how did you first learn about this case?
I will always remember the phone call that I received from local law enforcement indicating that we had a missing Fort Valley State University student named Anitra Gunn. I was with the district attorney's office in February of 2020. I received that phone call, and from the beginning, our office was involved in the initial steps relating to that investigation. I assisted and helped law enforcement in preparing and reviewing search warrants. We also helped in meeting and discussing potential investigative leads. Our office has always felt that it's important to cultivate a close working relationship with law enforcement so that the investigative steps that are done early on are done correctly and can lead to admissible evidence which we will ultimately present to a jury. And that was done in this particular case. We were able to take some of that evidence as a result of those early warrants and present that evidence to this jury. In addition, there was early on task force meetings. Not only our office, but local law enforcement from multiple jurisdictions gathered and met on a regular basis to discuss potential investigative leads, to look at potential suspects, and to talk about different steps that could be taken. And as the 14th and 15th went into the 16th and 17th, our office was involved in those task force meetings, and I personally was involved in those meetings as well. And then ultimately, as this case ultimately and unfortunately moved from a missing person investigation into a murder investigation, our office continued to work closely with law enforcement, both the local law enforcement initially and ultimately the Georgia Bureau of Investigations, who took over the investigation once it became a murder investigation. We, from the beginning, took this case very seriously. I took it very seriously, our office took it very seriously, and local law enforcement took it very seriously, because we all recognize, as District Attorney Howard has indicated, that domestic violence cases touch all communities, Black communities, brown communities, domestic violence cases touch impoverished communities, and we recognized from the beginning that this was a case that needed to have the utmost priority put with it. Our office did that, and local law enforcement did that as well. And as a result of that priority that was given to this case from the beginning, ultimately, as District Attorney Howard indicated, we were able to present evidence to the jury sufficient for them to return a verdict of guilty.
What were the biggest strengths and weaknesses as you put the case together?
In responding to this particular question, I took this two ways. One was from a prosecution effort, and the other was from an evidentiary effort. From a prosecution effort, this was an extremely large case. It had a lot of small pieces that had to be put together and had to be reviewed. There were thousands of pages of documentation from the phones in particular that had to be reviewed line by line. In order to do that, both Mr. Halverson and I had to be insulated from our other responsibilities within the office. It was simply not possible to present this case without going through everything, and it wasn't possible to do that, especially with the demand for speedy trial pending, without the assistance of everybody in this judicial circuit. We had other ADAs who stepped up and took on trials for us. We had other ADAs who stepped up and took on grand juries and regular motions to allow for us to be able to focus on that. Additionally, the law enforcement community was amazingly gracious and a huge strength for us that we continued this investigation literally up until the day we began to present the case. The bumper in the case was found only, I believe, 10 days before trial. That is a sign of the fact that the investigation continued through our office and law enforcement. From an evidentiary standpoint, the case was a circumstantial case. We explained that to the jury from the very beginning, that this was not a case in which anybody had actually witnessed the murder of Anitra Gunn, that we had to present who did this from a deduction standpoint. We had to remove other suspects, and we had to prove to the jury that those other suspects were not the individuals who brought about her death. Unfortunately, from prosecution standpoint, most prosecutors will tell you that there's been something called the CSI effect when it comes to jurors. Jurors now expect things like DNA, hair evidence, and things of that nature. From our perspective, this was a case in which, even though that evidence was present, because there was hair evidence presented, there was DNA evidence presented, it doesn't have the dramatic evidentiary impact that you would expect, especially if the people involved are in an intimate relationship. His fingerprints on the car, though part and parcel of the story, if he used her car, don't have that dramatic impact as opposed to a stranger. The same with DNA or hair. So from our perspective, we had that evidence, but the weight that was going to be given to it, we knew was going to be less because of the relationship. So from that angle, that was probably a weakness for us. Additionally, because we did not have any direct evidence, in other words, we didn't have an eyewitness to the homicide. From the strengths from an evidentiary point of view, definitely the cellular phone information was probably the most dramatic piece of evidence that allowed for us to actually physically place the defendant in the location where the body was recovered. That evidentiary weight is quite significant as compared to a lot of the other evidence that was presented. Additionally, the cellular information provided an insight into the relationship. A few text messages here or there may not have the weight that, from a prosecution standpoint, we would have wanted, but the consistent and regular abuse cycle that was demonstrated from the cell phone, particularly the defendant's cell phone, was, in my opinion, incredibly weighty in that it brought about the prior difficulties between the parties and set the scene for what eventually happened in the early morning hours of February 14. So from a prosecution standpoint, we were very fortunate to get the information that we did from the cell phone, and we believe that that was probably one of the greatest strengths to the case.
What was the picture that you wanted to give the jury?
That was the picture that we painted both in the opening and the closing, that the path that Anitra Gunn was on had only one destination. That domestic violence, if left to allow for it to cycle through its complete end, will usually end in homicide. There was a very frustrating aspect to this case because every single person involved in it was now looking at the relationship from a hindsight point of view. Everybody could see where this was going. Everybody who read the text messages, including the jury, could see where this was going. And I think from just a personal standpoint, as well as from a prosecution standpoint, we worried that was there going to be an ambivalence about what happened to Anitra because Anitra kept coming back. What was clear from the text messages and the evidence that was established about their relationship was that I think Anitra began to become desensitized to the threats as they slowly increased beginning in September of 2019, leading all the way up to the day before her homicide. I was raised by an old-fashioned lawyer who used to tell me the story of a frog, if you put it in boiling water, will immediately jump out. But if you put a frog in a cold pot of water and slowly turn up the heat, the frog doesn't know that it's boiling to death and will die. This felt like that kind of case, that as Anitra, if somebody had simply come up to her and struck her on the street, she would have reacted and defended herself and walked away. But because this was a slow, incremental, manipulative cycle that kept recycling itself, and that she became desensitized to it and she became adjusted to it, that even the most violent threats, the threats that we established of homicide, the threats of his own suicide, the threats of killing other individuals and killing her, she just simply ignored or tolerated. Didn't take as seriously as I think that had it been a stranger making those same threats to her that she would have taken as seriously. And so the picture that we want to paint is for those family members, and we saw the family and friends testify about the frustration that they had regarding the relationship. The picture that we wanted to paint was that despite the frustrating nature of domestic violence, especially from those of us that are sitting on the outside, that is to never give up, to keep fighting, to remind the individual who's in the cycle that they're in a dangerous pot of water and that it's going to come to a boil.
What was your key piece of evidence?
I believe that there were several key pieces of evidence. I would suggest that the defendant's own words, the defendant's own phone, and the defendant's own friend were several of the key pieces of evidence. Specifically, as it relates to the defendant's own words, as Senior Assistant District Attorney Baskin referenced, there were text messages that the jury had before them for consideration from the defendant, messages that the defendant had sent either to Anitra or to other individuals. And those text messages from the defendant, his own words, painted the picture that, as we've indicated, ultimately led to a destructive and violent relationship. In addition to that, the defendant's own words to Anitra's friends immediately after what we learned to be the time of her death. The defendant would tell Anitra's friends, as the jury heard, that Anitra left at around 11 o'clock and that she left for an interview. That was the same version of facts that the defendant shared with law enforcement. And we were able to show through the investigation of this case that that version was not true, was not accurate. And so the defendant's own words, not only in text messages, but the defendant's own words to Anitra's friends, and family as they expressed concern and worry early on, as early as the morning of February 14th. And finally, as it relates to the defendant's own words, his words on the stand. As the defendant opted to exercise his right to testify, he was subject to cross-examination, and the jury heard his statement, his testimony, and certainly evaluated his testimony in relation to the rest of the evidence in this case. And I think that his statement and testimony was a key piece of evidence that the jury considered. In addition to the defendant's own words, the defendant's own phone was a key piece of evidence. As alluded to, and as the jury heard the evidence, the defendant's phone placed the defendant in the woods where ultimately Anitra's body was recovered. The defendant's phone was able to place the defendant in the woods, and we were able, through the investigation of law enforcement and putting this case together, to show that his phone and the cache locations of his phone were verifiable. We were able to identify and confirm that the accuracy of the cache location data in his phone. And then I would finally suggest that the defendant's own friend was a key piece of evidence. The defendant's friend, to which the defendant confided. The defendant confessed to killing Anitra. The defendant confessed to his friend that he choked Anitra. The defendant confessed to his friend the circumstances of Anitra's last moments here on this earth. And the defendant's friend, burdened with that, ultimately decided to do the right thing and to share with law enforcement, and then ultimately to the jury, what the defendant had confided in him. And I would suggest that of the several pieces of evidence that the jury had to consider, that those were at least three of the key critical pieces of evidence for the jury.
What was your reaction to the verdict, and do you feel there's been justice for Anitra Gunn?
I've been doing this for a while, and every time a verdict comes down, I think that there's a perception that prosecutors are happy or elated. That's not really been my experience, and it wasn't my experience in this case. What I felt was relief that this particular chapter for Anitra and Anitra's family had come to a conclusion, and a conclusion that I believe reflected justice. I don't feel any happiness resulting from it because it doesn't bring Anitra back. So all I can say, as somebody who worked really hard to bring it about, is that I felt relief, and I hoped that it brought some measure of peace to the Gunn family, to the law enforcement that were emotionally tied to this case. I know it brought some to me. And I do believe that to the extent that the law allowed, that this was the justice that was deserving in this case.
All right, those are all of the questions that we have prepared. As I said initially, that we want to make sure that we don't do anything that will prejudice any appellate concerns. But did you all have any brief questions for us?
I did. What was the key moment in this, case that kind of helped jurors decide, make that decision of, finding him guilty?
The problem is And that's the problem with this particular case is I don't know that there was one specific moment. And it's one of the things that we warned the jury from the very beginning is that there was not going to be any aha moment. There were going to be several moments where pieces of evidence were put in that you could see the jurors nodding or going, mm-hmm, okay, and understanding that this was a piece of the puzzle. As we told the jury from the very beginning that this was not a puzzle with only 4 or 5 pieces, this was a puzzle with hundreds of pieces, and that you wouldn't even recognize the import of the piece of puzzle until you heard other pieces. So I do think that there were several moments during the course of the trial that you could just feel in the courtroom had an impact, particularly when some of the words of Demarcus Little was read. When he says murder in the first degree in his own words, I think that has an impact. But when the jury made the decision, I don't know that the jury was able to do that fully and completely until literally everything was presented.
Thank you. About how many text messages between Anitra and Demarcus do you believe were read to the court?
Actually read, it was a lot. I know I had 20 separate text message exchanges between Anitra and the defendant, and then there were an additional 12 or 13 between the defendant and other people where he was referencing the relationship. In those individual exchanges, I think there was 1 or 2 that were only a couple, but most of them ranged between 10 or 15 text messages up to, I think there was one series of text messages that was about 30 pages long. So, I mean, there were dozens and dozens, if not hundreds of text messages that were actually read. I'll state that that was not the complete picture. We have time constraints, and we had to pick out the ones that we believed would have the greatest evidentiary impact, but I will state that I read every single text message that the defendant sent to everybody that was on that phone to find his communication, not only with Anitra Gunn, but with everybody else. And I read every single text message between Anitra Gunn and Demarcus Little. And the ones that were presented definitely paint the picture, but unless you read every one of them, it's almost that you can't see a complete and utter picture of their relationship, but it was a very tragic thing to read. It was a novel that you read and you knew how it ended, but there were a significant number that were presented.
There was a hearing at the beginning of the trial where the judge ruled that her friends couldn't testify to statements that Anitra made to them, and then there was the evidence or the not being able to present Anitra's phone because of water damage. With the defendant not being convicted of malice murder, do you think that those 2 pieces of evidence had any impact on that?
No. The ruling, we stand by the court's ruling, but the evidence that we would have gotten through the friends, a great deal of that came in through the actual words of Demarcus Little and Anitra Gunn. So the insight into the relationship and the abusive nature of the relationship, I think, was clearly demonstrated there in the courtroom. And I feel like that the full picture of their relationship was established, even without that additional evidence. The friends would have testified to acts that they heard from Anitra. So that information came from Anitra's own words, and I think that there's even an argument that it actually had more power.
And as it relates to the phone, Anitra's phone, I think that speaks volumes to the continuing importance that law enforcement and our office placed on this case, in that efforts were made to attempt to retrieve data off of Anitra's phone. They were ultimately unsuccessful, as testified to before the jury, But law enforcement did not stop working on this case. Our office did not stop working on this case. We continued to pursue every potential evidentiary lead so that we could present to the jury the facts of this case. And so I appreciate the question as it relates to Anitra's phone, and I think it just speaks volumes to the fact that from the beginning up until literally the trial and through the trial, that our office and law enforcement gave this case the ultimate priority that it actually and appropriately deserved.
You mentioned how, there was a lot of evidence for this case. Did COVID play an impact in the progress of this case, or did that kind of, help you guys collect even more evidence for the case?
I think COVID has definitely played a part in all of the cases, as far as us being able to have grand juries and sessions, Baskin said, a measure of justice to the family.
If I recall, there were about 500 pieces of entered into evidence. Is that considered a lot, or is that about normal for a case of this stature, for lack of a better word?
I think when you're talking about homicides, that's probably relatively normal. I think that number is actually kind of deceptive because there actually were, when you had a piece of evidence, you had a number on a piece of evidence, you had pages and pages and pages attached to that. For example, the cell phones went in, the information on the cell phones went in as one large lump, but we spent a day reading that information. But I think it's always a bad idea to ever say that this case has more pieces as opposed to another case which may actually have larger pieces of evidence, or may perhaps just a video, and therefore you don't need 500 pieces of evidence to be able to present to a jury and say that that doesn't have as much or doesn't have as little. But 500 is not an outrageous number when you're dealing with a homicide, especially a homicide that is of a circumstantial nature.
And I think, as my team has said, we want to highlight just the efforts of law enforcement in this case. So many times in various communities, we hear the criticism of women from Black, brown, impoverished communities going missing, and the priority to find them is not what the community thinks the priority should be at. But here, there was no stone left, unturned, and that is why we do have the amount of evidence that we have, because of the efforts of law enforcement, the efforts of my staff. This case, since I took office, as I said, January 2021, people always say, if you need anything, let me know. If you need anything, let me know. This was the first time that I actually called the GBI director as we were preparing for this case, because they have a backlog, but there were some things that we just had to have. And so local law enforcement, the Georgia Bureau of Investigations, all played a vital and essential role of us bringing justice to this family. And we appreciate all of the efforts of law enforcement, and we can't say that enough. Thank you all so much.